Hi, I'm Mike Kalish, the Social Security lawyer, and in this video I want to talk about step 2 of the 5-step sequential evaluation, what I title, Are You Seeing a Doctor? And before we get into that, just to recap real quickly, when Social Security evaluates a claim for disability benefits, they're required to use in their evaluation process something that's called the 5-step sequential evaluation. All right, I call it the 5 questions. Essentially, this is an oversimplification, but it gets the concept across. Essentially, there are 5 questions that Social Security needs to answer when it's trying to determine whether or not an individual is eligible for disability benefits. Question 1 has to do with whether or not an individual is working and what that means under Social Security statutes. Question 2 has to do with the medical conditions, assuming that an individual is not working in the way that Social Security defines what it means to be working. Assuming that the answer is no, then we move on to question number 2, and that is what I call, are you seeing a doctor? It's the easiest way to put it. Understand that what we mean by sequential when we talk about these 5 questions is, again, just to review, you have to answer question number 1 before you move to question number 2. You have to answer 2 before 3, etc. So if the answer to question number 1 is, yeah, I'm still working and I'm earning over about $1,100 per month, it doesn't matter what medical conditions you have, it doesn't matter how unable you are to work because of your problems. If you're still able to work and you're still pulling down a salary, you are not disabled. Doesn't matter what's going on medically, all right? But assuming the answer is no, you're not working, then we move to question number 2, and I call that, are you seeing a doctor? Now, that's not what Social Security calls it. They have a very formal legalistic definition. Essentially, they require evidence of something that they call a medically determinable impairment. I'll get into what that means in a second. This medically determinable impairment must exist for 12 months. Either it's already been in existence for 12 months, or it's reasonable to expect it to continue for at least 12 months into the future, or the condition's terminal. All right. And the third part of this is that this medically determinable impairment must result in limitations that impact an individual's ability to work. All right. So we have to have a medically determinable impairment. It has to last 12 months or be terminal, and it has to result in limitations that impact on a person's ability to perform basic work functions. It's a lot of information. I'll break it down. All right. So let's begin at the beginning. What is a medically determinable impairment? This is a medical condition. All right. This is what in common language we would think of when you go see a doctor because your back hurts, or you have a diagnosis of cancer, or you have a psychological problem, you have a schizoaffective disorder, you suffer from depression or bipolar disorder. These are medical conditions. These have to be established by doctors who are certified and licensed in their areas of expertise, right? So it's not enough to just go in and say, my back hurts, or I feel very sad all the time, I'm crying all the time. You have to have, Social Security requires medical documentation of the problem, all right? This comes up in this context too, where most people get it that you got to have medical records to support a claim, but a lot of times I'll get clients who will come in and they say, hey, I got this great letter from my doctor, and this letter says, hey doc, or the letter from the doctor saying, hey, my patient is unable to do any type of full-time work. She's got the following conditions, and these wipe out her ability to work full-time. All right. The problem with these kinds of statements from the doctors, and I know they're well intended by the doctors, is that these statements are conclusory, meaning that they give us the answer without giving us an explanation for the answer. The way I describe it is, if you can think of it as a metaphor, you think of a table, right? The table top is your conclusion. He can't work, he's disabled. But a table is nothing without the legs. The tabletop in and of itself is not going to get us there. We need the legs. What are the legs to the table? Evidence. What kinds of evidence? We need things like x-rays. We need things like MRIs. We need things like psychological testing, if it's a psychological condition. Examinations that show that when the doctor does certain examinations, it's obvious that the signs that they're getting back indicate there's an underlying medical problem. So those are the legs of the table. We have to have those objective, discrete pieces of facts, objective, discrete facts, to support the conclusion that you're unable to work. Without that, we're not going to get past the second step. The reason being that symptoms alone, the fact that you're in pain, that's a symptom. When you say I hurt, that's a symptom. That's not sufficient to win the case. The judge, the law, the way I explain it to my clients is like is this way. I could wheel you into the hearing room on a gurney with a bunch of tubes sticking out of you. You don't have to be a doctor to know when a person is in pain. You don't have to go to medical school to realize, hey, that person's got some problems. Nevertheless, the law says to the judge, before you can award somebody their disability benefits, you must have medical documentation. There's got to be some objective medical documentation establishing the underlying problem. Without that, the claim, we're not going to get past second base. The judge cannot pay the case, can't do it. So it's so important that you're seeing a doctor for these claims. The second piece of that puzzle is you have to have that medically determinable condition, impairment. It has to be documented by, as I mentioned, objective tests that are accepted by the medical community, x-rays, MRIs, psychological testing, EKGs, lab work, those sorts of things. In addition, the condition has to be expected to last 12 months. So, for an example, a construction worker may go out and have an accident and end up with a broken leg. He can't work, do the job as a construction worker with the broken leg, but barring anything unusual, the leg should heal up certainly within 12 months, such that he'd be able to go back to work. Because the condition isn't expected to last 12 months, or it hasn't already lasted 12 months, and it's not terminal in and of itself, then that's not going to make it. That's not enough. You have this durational requirement of 12 months. And the last piece of the puzzle here is it has to create limitations, problems that interfere with a person's ability to work, to perform basic work activities. And what I mean by basic work activities is things like showing up for work on time every day, doing whatever the job it requires. If it's an office job, you have to be able to work on the computer. You have to be able to do the filing. You got to be able to answer the telephone. If you have a medical condition that doesn't interfere with your ability to do those sorts of things, well, then again, it's not going to meet the elements that are required for Social Security to pay the claim. The example I use here is there's millions and millions of people, unfortunately, who suffer from diabetes. Everybody would agree that diabetes is a very serious medical condition. It's a severe medical condition. It requires treatment. But if an individual complies with their regimen of treatment, whether it's medication or exercise or diet, and they're able to control their blood sugars, even though they have this condition, it's not causing any problems with their ability to go in and do the job. All right? So, to recap, you must be seeing a doctor, right? Because you're not going to get this evidence without being in medical treatment. You've got to be seeing the doctor, and you've got to be seeing the doctor regularly. When you go in to do the hearing, that's 90% of what these hearings are about are the medical records. They turn on the medical records and how well documented the condition is. Then, once the condition is established, then and only then can we talk about how the condition interferes with an individual's ability to perform their job. So, step one, are you working? If the answer is no, we go to step two. Do we have the medically determinable impairment? Has it lasted 12 months? Is it expected to last 12 months? Is it terminal? If the answer to all of that is yes, then the next question is, does it create problems that interfere with your ability to work? If the answer is yes to all three of those pieces of the puzzle, then we move on to question number 3. If the answer is no, I'm not in treatment, I don't have records, the condition is not expected to last 12 months, or the condition doesn't create any limitations or problems for me to be able to do basic work activity, in that situation, you're not disabled and the claim will be closed out at that point. If the answer is yes to all 3, then we move on to question number 3. If you have any questions, I know it's a complicated topic, give me a call, 714-548-3292. Again, 714-548-3292. Again, my name is Mike Kalish. I'm an attorney. I hope you found this helpful in trying to understand this process, and thank you for watching.